Hello, NLD. We're back for another episode of NLD Stars. Today, we're with Jen Lipinski to talk about her recent $2.6 million verdict, our former chair of the NLD caucus. Hey, Jen.
Hi, Jared.
Thanks for joining us. So
For having me.
tell us a little bit about the case.
So this case, this case involved an unfortunate sexual assault that happened in the Ocala, Gainesville area in Florida. So we are in kind of a conservative area where the location of it occurred. And so my client went to a rehab facility with significant prior sexual trauma and significant prior alcohol and drug dependency issues. She was abused as a child, and what we know is oftentimes individuals who are victims of child sexual abuse often will abuse alcohol and or drugs, and then it kind of starts this vicious cycle. So she had gone to this rehab facility, and it was the first time she went to a facility that specialized specifically in sexual trauma, in addition to alcohol and substance abuse issues. And she went there and she was unfortunately abused. It's estimated 10 times by a personal trainer that worked there.
Wow. And the one major thing that jumped out to me when the post came around telling us all about your verdict is that the last offer before trial was $10,000.
Yeah.
And your team came out with a $2.6 million verdict. Talk to us a little bit about your approach to damages. How did you put those type of numbers on the board?
So the damages also were entirely non-economic damages, which I know for a lot of us, it's really scary because oftentimes jurors don't see non-economic damages. Right. So what we had decided was, because of her significant prior history, she'd gone to a lot of facilities before the one that was the defendant in our case, is that we wanted to not feel like we were overreaching to the jury. And so she subsequently treated for these issues after the abuse occurred. And so we were afraid that they would nitpick the actual expenses for the treatment post the admission to this facility and say, well, look, she had all this going on before, and here the plaintiff is trying to be greedy and trying to take away all of this. So we had decided against taking that approach. One thing we were able to learn through discovery was that this facility charged about $1,000 a day for patients to be there. And so our approach was initially is that, and she was there for 168 days total. So our approach initially was, well, we're not going to ask for the past medical expenses or future medical expenses, but we do think because her treatment was compromised, we would ask the judge for her to be paid back for that $168,000 while she was there, because the entire time she was essentially being abused. So we went back and forth with that issue, and we were able to get the judge to allow us to talk about the $1,000 per day. And we also, within the liability portion, we told them, like, here, this is a negligent supervision. That's not like she's paying $50 a day to be there. They're getting $1,000 a day to supervise this person who's being abused at their hands. So we thought that was an important point for the jury to hear as well when they were assessing negligence with regard to the facility. And the other thing related to that is we had initially a vicarious claim for the person, for the rehab facility, and also a direct negligence claim. Well, the judge, because of the law in Florida, because of the criminal acts, ultimately DV'd out the vicarious claim for the person that did this. And so we had to make sure we were establishing the direct negligence of the actual facility. So we thought that that was important. Ultimately, the judge, the night before closing, said, you know what? I am not going to let you board that $168,000. But we still had obviously gotten through the evidence that it was $1,000 in a day. And so I talked a little bit about it in closing, just that it was the $1,000 that they are supposed to be taking care of her. And so we kind of used that, I think, as an anchoring form for the jury. When it came to damages, and I think it's interesting for this is only plaintiff's lawyers, but I think a lot of us are surprised, especially new lawyers, at how damages evolves even up until, the actual trial, till closing arguments. And the night before, I had been thinking about damages for a really long time, and I didn't want to undervalue these significant events that happened to my client. But because I'm in conservative Florida, I didn't want to overvalue it in a way that felt like I was disconnected to the jury too. So I had to kind of balance those two things. And so ultimately what I came to the conclusion is I was going to ask, so our client is 31 years old. So I decided I was going to ask for $75,000 a year. And I said, let's be clear, this is not $75,000 like a job. My client, we're not trying to ask that whatsoever. This is the value of what this has caused our client and the pain that she has to deal with this and the rest of her life. And I explained, because she was abused in the place that she was supposed to feel safe, and someone who has struggled with substance abuse issues, she's going to have to continue to treat places through the rest of her life with always the thought of what happened to her by that defendant of, is another person going to try to abuse me? And that value was worth $75,000 per year going to the next 40 plus years of her life. And so ultimately, I think my total came to like 4 million and the jury gave it 2.6. So
wow. So you hit on really three different aspects there. And it was the way I was, your client's testimony, how you dealt with the liability case, the direct, negligence case, and then how you sat that table at closing. So let's go back to your client, right? I mean, in order to ask for what you did at closing, you have to obviously set the testimony with your client and how this has affected her and will impact her going forward. Talk to us a little bit about how you handled your direct of your own client.
So I got to know, I was brought into this case to try it. So I wasn't involved with the case in the beginning, but once I got involved, I became really connected with our client and tried to spend a lot of individual time getting to know her. I think that that's crucial for anyone who wants to try to effectively communicate damages, that you want to know, you want to spend as much of time as possible with your actual client. So when you're asking the direct, you are talking to your client as if they're a friend, not as just someone who you're getting through a checklist. And I think that emotion that you can evoke when you're connected and you really spend that time with them comes off the more time that you spend with them. So that's one thing. Second is there is a woman by the name of Ilya German who does some witness prep, and she was fantastic. And I called her the week before trial and I said, look, I know you've been booked, but I would love for you to spend a little time with my client. And she was just amazing in trying to get my client there, because naturally with a lot of cases, but especially a case like this, my client would it was hard to get deep into what happened to her for a variety of reasons. And I also wanted to make sure that I was not doing anything that could potentially re-traumatize my client. So it was a very delicate issue that I wanted to make sure to convey the damages that she had without further harming her in any way. And so I worked with Ilya, and we did some Zoom meetings and got my client to really talk about how this impacted her in a way that I think was really effective, which gave me the tools during her direct examination to talk about things. For example, I asked her, during the first assault, what was going through her head, and that my client previously, when she would have, her substance abuse issues, she did have prior escorting going on. And so that was another fact that the defense was using. So she told me in some of the prep that, as in that first moment, that it was this realization of this was all that she was ever going to be. And I just thought that was gives me chills thinking about it now. It's just such a crushing feeling that she's there for help, and she told them all of these things, and then they pretty much use that against her and try to say, we're not responsible. So I think that getting to know your client really early on as possible, and spending as much time as you can is really essential for that.
That's very powerful testimony, and I think it ties directly into I guess probably a cross of their liability expert or your liability case, right? Trying to take what she divulged to them in confidence, and that betrayal of trust that so tell us a little bit more about the liability case.
So they had their liability expert actually testified a lot on behalf of tobacco companies, which I know your firm does a lot of tobacco. So you may even know her name's Deborah Barnett. Have you ever heard of her
Yes.
before? So she so it was interesting, you know, she's just, you know, corporation's best friend. And I kind of pulled that out a little bit in cross. And so you know, one of the things that we utilize, and I think that's why it's so important for a really effective cross at trial. You have to be so prepared for your your examination of them for their deposition, because I put so much work into that, got so many great concessions during her deposition, and her deposition was just a week or two before trial. So I got these concessions where I was able to create a really effective cross. And I asked her some questions and she's like, well, I don't know. And I said, well, I asked you 2 weeks ago and you didn't know. We're here at trial right now. You still don't know the answer. So I think that that was really effective. And one thing I was texting some of my trial friends, what was really great is I got during her deposition that she had 42 cases. And I counted up, we took time, it took a lot of time going through everything, but these 7 pages I went through and said, which one of these are plaintiffs? Okay, and then some of them were not plaintiff or defendant, but she would try to call them as plaintiffs, but we got it all, you know, outlined. So I got something like 83% was for the defense, and like over half were for big tobacco, and got her to concede that they were always that the person wasn't addicted to cigarettes, you know, despite them dying of lung cancer with lots of cigarette use. So, and then I pulled some depots because our office does tobacco too, and saw that it seemed like she was getting 10 to 20 grand on every case, like by depot time.
Yeah.
So I got her to concede at trial that by the time, you know, on this list, she's probably got somewhere between, I think I got her down to like 15 to 20,000 per case. And she was like, yeah, probably. And I'm like, sure, there's some probably been paid more, some you've been paid less. And so I got a whiteboard up and I did it at the very end. After I got all these really great concessions from her, I just typed, I went up, okay, 42, and I had out my phone and I'm going, okay, now 17,000 per case. And I'm doing the math and I said, you testified you have now 10 active tobacco cases. Okay, so that's another, and I'm going through this and the defense is objecting. And the judge is like, this is cross-examination.
Right. Yeah.
And so I ended up pulling up like $1 million she's been paid by corporations. And then I asked her, you know, like another, and you know, and there's still not one policy with regard to sexual assault. Okay, great. And I sat down and it was just like, it's cross-examination could just be so fun, but you don't always get a lot of good stuff. It just depends on the case. So really the more that you can get in the deposition, it just makes for a lot more fun at trial.
Right. And, you know, the advantage of taking deposition, especially back close to trial, is being able to box in the expert into their testimony, and then they can't back on it. And then you've got some more wiggle room at trial to have some fun.
Absolutely. And it was interesting because even at the deposition, the defense attorney, I took like 4 hours with her. And she decided she wanted to do it on Good Friday and then complained about it. And I was like, you're the only one, you and your expert could only be available this day. And I think it was like 3 hours in, I finally asked her opinions, because I think for us to effectively do our job, there's so much other than her opinions that we actually care about, you know, like the records she reviewed, there's so many holes and they have all these opinions, but basic important records they don't have, you know, so she can have those opinions. When I ask her where the policies are, well, I actually was never sent those policies. Well, you know, those are way more important than her opinion. So I think just kind of not feeding into the defense because she was getting so frustrated with me. It's like, no, you do your job and I'll do mine.
Yeah, absolutely. And so it sounds like you had a number of effective anchors throughout your trial, right? For damages. You had the $1,000 per day. You've had, you know, putting up on the whiteboard what the defense's expert is making per case and how much they have made recently, testifying, being the corporate friend. And then you had the $75,000 per year moving forward. One, how did you tie that all together at trial? And two, was there any reason why in the eve before your closing you chose the $75,000 figure as opposed to a different amount?
Well, it's interesting because we had talked about, you know, numbers and stuff. And at one point, we were like, okay, maybe we ask for $1 million. And I talked to some people when I went to AAJ in Chicago, the quarterly, and I talked to our friend Rick. And I told Rick he needs to start talking about damages because he got, I think, like a $50 or $70 million verdict. And so I asked him, how do you with a straight face ask for $70 million without having like your lip curl? And so he kind of had this really good heart to heart with me about, well, what do you believe in? And I called Rick right after the verdict and I thanked him because, you know, I was like at 1 million and 2 million and kind of going through the numbers. And I just felt like I was shortchanging my client. And it just didn't feel to me, I didn't believe in that low amount. I genuinely believed in my heart that it was worth more.
Right.
And so I'm like right about to start closing and I'm reconfiguring my numbers at the 75 because I was like, nope. And I told my trial partner, I was like, this is the number I'm asking for. And I told the client, she's like, well, they've offered us 10 grand. So girl, do you? So I think that was really, really great advice is, you know, really thinking about what the damages are. And it's something that evolves, you know, you don't know how the trial is going to go. And so that's why I think a lot of really good trial lawyers are constantly tweaking that even until the last moments before closing.
Well, yeah, it's very good advice. And Jen, before we let you go, do you have any other takeaways, lessons learned to be moving forward?
So I go to a lot of these like trial seminars and different things like that when I can. I think all of us are trying to be the best lawyer that we can. One thing that was a really cool moment for me in the trial was I had decided the morning of closings that because this was a sexual assault case, when I kind of mentioned to you with direct with the first assault, how like my client saying that, you know, this was all that I was going to be. So and I told my trial partner and my client as we were on our way to the courthouse that morning what I was going to do, so they weren't surprised. So but I actually during trial, as I was, you know, I went through the evidence on liability. And then I think to really bring home the damages, what I did is I went through a reminder of what happened to our client. And then I physically, like I kind of took her into my being. And I, during closing, actually went down to my knees and looked up and like, you know, the jury's here. And I just sort of looked up and I said out loud, like, this is all I'm ever going to be. And I just paused. And that I think was just such a powerful moment because it's hard. I think like that was the strongest part of the case of the injuries that my client got. And I think sometimes we focus on these just little issues, but that was the crux of the case is how this guy thought he could get away with it. They weren't supervising him. And that put my client in that position that she should have never been in. And so it felt kind of risky to do something like that. But I've had a lot of fun in the more cases I try of doing things that feel outside of the box. And I think it was effective. And of course, like the defense attorney didn't object. What does he object to that? Right. There are moments where if you object, you're just going to make yourself look bad, right. You know, and he certainly had plenty of objections during closing. So I would say just think sometimes outside the box on what your approach is and how you can effectively tell your client's story. And, you know, it can be a lot of fun sometimes. So.
Well, you know, that's the privilege that we have as representing plaintiffs, being trial lawyers, being able to tell the stories that need to be told and advocating for our clients. And your client was tremendously fortunate and privileged to have you as her advocate. And this was so an amazing result, a great verdict, a great service to your client. So thank you so much for joining us and giving us your insights of this trial. And we hope we could talk again with you soon.
Thank you so much.